What's up, everybody? Welcome back into another episode of The Lawyer You Know. We had another hearing today for Karen Reed. We didn't get through everything, but we got through enough to know the defense has taken some very legitimate swings at a couple of the Commonwealth's experts. The Commonwealth has agreed to limit what at least some of those experts are going to testify. And we heard in open court from Hank Brennan's mouth that the federal investigation is closed. Does it make sense with the other context we got in the hearing? Does it make sense with what's being reported afterwards? What's going on with that federal investigation? Is it going to matter to trial too? We'll talk about that and, of course, answer all of your questions in today's video. So go ahead and hit that like button and let's get started. All right, so we're going to jump right into this hearing, and I want to start almost at the beginning where Judge Cannone, who has had a week since the last hearing to chew on what was said and testify to, she still hasn't made her decision yet on what's going to happen. Is she going to, remove Alan Jackson? Is she going to reprimand any of these attorneys on either side for some of the purported wrongdoing? What is she going to do with all of that? Well, she had a few questions right off the jump, and even some comments that I found to be interesting that we have talked about on this video, or on this channel, I should say, in the prior few videos about what is an individual defense attorney's responsibility for what the other attorneys know or don't know, say or don't say, turn over in discovery or don't turn over. By the way, there's a possibility, it's not a guarantee, but there is a possibility that my dad will come on later in the show to talk about said federal investigation. So Kelsey, will you send him a link just in case he is able to jump on and join us later when we get to that part of the hearing? So that would be a nice surprise if it happens. But if not, we're going to talk about it either way. So let's start with what Judge Cannone had to say to the defense team and questions she had for Karen Reed's lawyers about everything that went on last week.
So the questions that I have, before we start, so I want it to be very clear, counsel knows this. There has been some attempt at distinction between defense counsel. Mr. Yannetti wasn't on the emails. Ms. Little wrote the pleadings that everyone signed. Mr. Alessi's late to the game here. But you all know that when one of you speaks, you speak for the entirety of the defense team. When one of you acts, you act for the entirety of the defense team. And when one of you makes representations or misrepresentations, you speak for the entire defense team. You know that. Do you understand that, Mr. Yannetti?
I do.
Mr. Jackson? Of course. Ms. Little?
Yes.
And Mr. Alessi?
Yes, Your Honor.
So what was interesting about that is I agree. And that's exactly what I said, especially as it does with the work done on the case. You can't just say, oh, judge, not my job. We're splitting, divide and conquer, which is exactly what I said. But there is some distinction when it comes to specific knowing wrongdoing. Alessi brings that up in a second. We're going to hear him make that argument. But she specifically says, and with individual misrepresentations. And all of them agreed. Alessi does fix it later, but I was a little bit surprised they all agreed, even though she's completely right when it comes to do with the work on the case. You can't say, well, judge, that's not my problem because Ms. Little did it. You just can't do that when it comes to the actual work on the case as a defense team, just like the prosecutors can't do that, even with a special prosecutor, which is much different. These are a bunch of defense attorneys from different firms, so there is kind of that similar feel and vibe. But let's listen in for, or actually, we're going to jump ahead a little bit. She did want to ask Alessi about the pause email. And he said that he inferred that there was no discussion, text messages, emails between ARCA and the defense team. She asked, did you actually talk to them and confirm with the defense team there was no discussion, or are you just inferring it? He said he's just inferring it. She didn't seem real happy about that. But then they get to the invoice and discussions about whether or not that was appropriately discovered and discussed when they found out about it. So let's listen to this exchange.
Midway through your proceedings. And in fact, I have the opposite. I have filed after that February 13th.
Same time as what, Your Honor?
As the invoice.
And you're referring to the record of payment being?
Yes, so I was provided
Sorry, I backed it up because I missed her actual question. Here's her actual question.
to the Commonwealth. The invoice was provided on February 13th, 2025, provided to the Commonwealth. The bill itself was paid on July 25th, 2024. Why wasn't the record of payment produced at the same time
Same time as what, Your Honor?
as the invoice?
And you're referring to the record of payment being?
Yes, why wasn't the fact that this payment was made? It didn't come out, for me, at least for the court, until I asked you midway.
He's not playing dumb, by the way. He means, did you want a copy of like the check that we paid it? Do you want the log that shows, when it was paid? What do you mean by a record of the payment? She just meant, when were you going to tell us that the defense did in fact pay these experts? That's the question she's asking.
Through your proceedings. And in fact, I have the opposite. I have filed after that February 13th date, and I know Ms. Little filed something yesterday to clarify this. It seems pretty clear. This was filed, I believe, in the weekend, February 16th. In the Commonwealth's defendant's opposition to the Commonwealth's motion to exclude employees of ACA, the Commonwealth's motion to exclude these exculpatory expert witnesses who were not hired or paid for by the defense is not made in good faith in a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. Going on to the next page, ironically, the Commonwealth accuses the defendant of failing to comply with their discovery obligations while conceding that the information is not in her care, custody, or control. Moreover, here, the defense has gone above and beyond its reciprocal discovery obligations and has already satisfied all of its mandatory discovery obligations under Rule 14 and turned over all additional information in the control and custody of the defense relating to the ACA witnesses as ordered by the court at the last hearing, in spite of the fact that the defendant's reciprocal discovery is not yet due. How do you reconcile that? I had to ask you midway through your presentation whether that bill was paid.
I'm going to answer it, Your Honor. I just want to make sure you were finished with your question.
It's like, have you ever gotten in an argument with somebody that they'll talk and then they'll talk more and then they'll talk more, and sometimes they get annoyed with you that you haven't responded to any of the subject matters that they've brought up, and you're like, I couldn't tell if you were finished. And he's like, I have an answer for you, Judge. I'd like to respond. I just want to make sure you're done with all of your questions.
I learned that invoice was paid Sunday night before February 18th. I'm going to repeat that. I learned.
You don't have
I'm
to
sorry.
repeat it. And again, what you know and what all counsel know is one and the same.
I understand, Your Honor. And I want to, so I'm answering your question. That's part one of the answer. When that was submitted on the 16th, I had not gone and done my investigation and gone through and asked all the questions that I did. So that's part one. Part two of the answer is, Your Honor, you've referenced that I didn't get to the payment until the middle of my presentation. The reason is because I did my presentation in chronological order. And that's the notebook that I laid out. I started with March, went all the way through.
And it's so good. And it's like the Alessi style that if you love him, you think is awesome. If you hate him, you think it's annoying, where he sets out exactly where he's going to go. And then he goes there. He's like, I was going chronologically, Judge, and it happened later in the case than the stuff I was talking about at the beginning. So that's where it came into the discussion.
Through. And when I got to the invoice, before I could state that it was paid, Your Honor asked the question, was it paid? And my answer was right away, yes, it was paid. And I said, and that's what I was going to get to next. So the reason why it came out when it did is because I did the whole presentation in chronological order.
But the motion, defendant's opposition to the Commonwealth's motion to exclude employees of ACA is signed by you.
Your Honor, it is signed by me, but if I could, with regard to 3.3A1, 3.3A.
So here's the difference he's going to get to in a lawyer's responsibility for other lawyers and what you can and can't be held responsible for another lawyer, even if it's on your team, another lawyer doing.
One is not a strict liability statute. That's the reason why it has knowing in it, is in order to violate 3.3A1, the attorney in question has to know with regard to the fact and issue. So respectfully, Your Honor, I have a different view of what an attorney is responsible for under 3.3A1. You're absolutely correct. Under everything else, particularly Rule 14, it can be no excuse for any attorney, including me, that I didn't know what was happening in discovery. That's not the way Rule 14 works. I am responsible for everybody. But Your Honor, it's clear in the commentary, it's clear in the case law. The reason why knowing is with regard to each attorney is no attorney can be responsible for the statements of issues of fact in court when it comes to a 3.3A1 analysis. That analysis and construction, Your Honor, would render mere surplusage and read out the mens rea of knowing. in something that critical of candor to the court. That's why they put the mens rea in, because no attorney can be responsible for a misstatement of fact of another attorney unless they have knowledge of the misstatement and they knowingly participate. So I respectfully have a different conclusion than Your Honor does about attorneys being responsible for statements on candor under 3.3a from everything else in the world, which I agree completely with Your Honor.
So he's completely right. And let me explain to you real quick, just so you can understand why it's different, right? First off, a very easy way to understand is there's a difference between intentional acts and negligent acts. We all understand that. And there are statutes written that way specifically. For example, in civil law, if you do something intentionally, there can be punitive damages. If you do something negligently, usually there's not. There can if there's reckless indifference for human life and things like that. But you understand it's always worse if you intentionally do something rather than negligently do something, as it should. If I were to go to any jury and I was going to ask them for money and one defendant accidentally T-boned my client because, they weren't paying attention, okay? Versus another one was angry at my client and they ran that red light and hit my client on purpose. Who do you think they're going to hammer more? Well, there's a reason for that, because intentional misconduct is always worse than negligent misconduct. That's number one. Number two, we know how precise lawyers are. We have read so many things about know or should have known. We read things like reckless indifference of human life or safety. We read things like intentional misconduct, negligent misconduct, accidentally done, shall do, may do. Words are so important in all these statutes. We know that. And this is how the statutes are written and the rules are written. And then to take it a step further, the reason this rule is specifically written with this mens rea and the higher bar of knowingly, intentionally doing something wrong. You have to know that what you're saying is wrong and not fix it, right? Why do you think that is? Why do you think it seems like, gosh, lawyers really have to do something bad in order to get sanctioned under this rule? And I would agree with you. It's a pretty high bar, meaning a lawyer's got to be really bad. Maybe it should be lower. It's not, but maybe it should be. But we deal with the law as it is, right? So why do we think it's like that? Well, who writes these laws that govern lawyer misconduct? Lawyers. Do you think lawyers want to get sanctioned? How do you think a lawyer is going to write a rule that affects lawyer conduct or misconduct? Florida has been rewriting the rules over the last couple of years. I've been on rules committees and we've talked a lot about sanctions, and a lot of the lawyers in the room, I won't say what kind of law they practice necessarily, but they're like, well, Mr. Tragos, we don't want to get too heavy-handed with sanctions. We want to give the judge discretion. We want to make sure a lawyer has to really do something bad to get sanctioned because we all make mistakes. We're human. Lawyers write the rules. They don't want to make it easy to get sanctioned for their actions, whether you like that or not. That's how the rules are in place at this point. I absolutely agree with the way Alessi just explained it. Does that mean that's the way Cannone is going to rule? I don't know. Caitlin makes a point on this comment. How is the law so subjective in this case? I don't get how a judge can be this way with the defense and no ramifications. Why not replace like YSL? So YSL was so much worse than this case for a number of different reasons, especially with the ex parte hearing, which really was what was the straw that broke the camel's back. But what I'll tell you is it's not the law that is subjective. It is judicial discretion that's subjective. Because so many laws are very similar and a judge has discretion to do X or Y. They can't abuse that discretion, meaning go too far. But that's what's subjective, is an individual judge's discretion. And I get why you feel that way, and it can be applied differently depending on the side. And usually judges favor the prosecution. That's just statistically speaking, that's how it goes. All right. Next is the motion to exclude Crosby, who is the dog bite expert for the Commonwealth. We read this motion together. Alessi destroys this guy. Plainly not qualified. Methodology not reliable, not even documented. He is trying to confuse it and camouflage what he's actually testifying to. He's not a medical doctor. Even the judge said he has to be a medical doctor. He's a canine expert. His methodology basically is measuring Chloe's teeth. Now, he says he took a mold in a very late filed document, but even with that, he did that wrong. And he's trying to use those to say that this couldn't have happened from Chloe or any other animal. He goes through all the errors that Dr. Russell swore in her affidavit to, it being a static object, et cetera, et cetera. let's just listen to a couple minutes of him basically tearing apart the methodology used by Dr. Crosby.
But what he misses is those molds are meaningless unless you come to part two. You've got to take those molds and compare it to something. And the something is what's called the overlay method. And what is the overlay method? And this is all set forth in our opposition. And I've got citations to the exhibits, which I'm going to go to. The overlay method is the part two you apply the mold to. So what you do is you take tissue samples of the wound and you make, there's a variety of techniques you can do, but you basically create the wound on a model, and then you compare the mold to the model to see if they match up or don't match up. He never engaged in the second part of what is, even with two parts, is a questionable methodology. He doesn't employ the overlay method, the part two. So the molds that he took are meaningless unless you have the overlay to go with it, because that's what you compare them to. More importantly, the ABHO makes it clear that the only people that can do that are forensic odontologists. And even then, the science is very questionable. What he also does in terms of, and also for his methodology, where it's just a measurement, he provides zero citations, and the Commonwealth provides zero support for taking measurements in molds and comparing them to the wound. Zero. So what are the other errors of Dr. Crosby? And these are not mere differences of opinion, Your Honor. These go right to the methodology. And we put in an affidavit of Dr. Russell, who is the medical support for his errors. So Dr. Russell goes through and talks about all the errors that Dr. Crosby caused in his analysis. The first, she says, is that he treated the arm of the decedent as if it is a static plastic mannequin-like object. And what is meant by that?
And we know why that's wrong, because Russell explains how you move your arm when you're getting attacked. That makes, logical sense. But the real point is, and the reason the defense is fighting so hard against this witness, you get a little idea of how Alessi would destroy him on cross. Alessi read his master's thesis and his PhD thesis, which was 179 pages and 143 pages. And he talks zero about his methodology. He actually does discuss the pattern recognition that Dr. Russell is going to use. But even though you would destroy him on cross, there are just jurors that will believe things that an expert says because the judge lets them sit up there and say that they're an expert, because the state trusts them and we trust the government and we trust law enforcement. And I know there are people that don't. I'm just saying that's why it's so important to get somebody like this struck, especially because he says the guy was basically a cop and he's got a degree in veterinary science, which is not a veterinarian. Okay. And it's important to get him struck, but I'm going to hold till the end of what I think is going to happen. Brennan responds and says he agrees there's a lot of differences between Dr. Russell and Dr. Crosby. Dr. Crosby's actually testified as a dog bite expert before, and Dr. Russell hasn't. He's actually examined and molded Chloe's mouth. And the one good argument that I did think Brennan made, which I said from the jump, that Judge Cannone said, because you're not an MD, you can't be an expert. That's not actually a legal principle. And so he's saying, just because the judge has said that doesn't mean that's how the law is. And the judge needs to look at the law and see that you can testify as a dog bite expert, even if you're not a medical doctor. You can testify about how wounds get there, even if you're not a medical doctor. That is actually correct. But anytime you can use the judge's words as part of your argument, you absolutely should. And the defense was smart to do that. Additionally, he said Dr. Crosby would only be called in rebuttal, not in the Commonwealth's case in chief, which is good because you don't want to overtry this case. More on that later. And then Alessi comes back with a great response to what Brennan had to say about what I thought was a great point by Brennan, as well as that, hey, Crosby's actually testified as an expert here before and Russell hasn't. Okay, on its face, that's a good lawyer argument, right? Lawyer has something to say, that's what he says it, but did he provide all the facts?
The Commonwealth did not address in its presentation, you heard one probative, legal, or factual point I made because they can't. Specifically, the Commonwealth just stated that...
Even the decent points Brennan made, none of it was about his qualifications. None of it was about his methodology. None of it was about how he got to his opinions in this case. It was purely like, hey, judge, other courts have allowed him to testify as an expert, and you should too. That was basically Brennan's argument. Sometimes that works. Sometimes it does. But a really good response by Alessi.
Dr. Crosby has testified in court numerous times. On what? It's important. You can be qualified to testify. And if it's what Dr. Crosby does on behavior, dog behavior, was the dog an aggressive dog? I get it. But the Commonwealth never said that in even one of those cases, Dr. Crosby testified on whether the cause of a wound was from a wound to a human was from a dog. Wasn't mentioned. There's no case provided. As best as I could, I looked at those cases. I couldn't find many of them, but I didn't see any indication that he testified and was allowed to testify that the cause of this wound on a human was from a dog or a specific dog. Point number two, Mr. Brennan mentioned he cited numerous journals. Your Honor, I would ask the court to take a look at his report. There is now.
Hold on, so that's exhibit 1. Is
Yes, exactly.
Just put it back in.
What he finishes with is he basically says, these journals may influence my opinion. That's not appropriate. You have to specifically talk about which ones do so that lawyers can cross you on it and we can actually understand and have our experts look at it. And we've kind of been over this as we did the response. But what did he actually testify as an expert to? Brennan gets up and is like, I'll provide the court and the defense with all of his prior testimony. But he doesn't say, which he just could, judge, 20 times he's testified as a dog bite expert that these wounds on somebody's arm are from a dog or not from a dog. Never did he say that. I don't know why. If it exists and it's true and your expert has done it, that would be great evidence for you and great for your argument. He also says, Dr. Russell didn't even, this is Brennan, Dr. Russell didn't even give us her methodology until very late in her testimony, judge. It's like, but at least she gave it because it doesn't seem like Crosby did. The defense also says, we don't even think we need a Daubert hearing because Crosby is so far away from what's appropriate. Brisby said, how can Brennan argue not having evidence with a straight face? As soon as the police has it, prosecution is deemed to have it. Any criminal lawyer should know that. Yeah, I don't think he would take too kindly to this argument being made by somebody else. Bill Foster, do you think Lally is paying attention to these arguments or just chilling out, daydreaming, etc.? Guy looks bored. I don't know. It's like, depending on his personality, either he loves it that, it's no sweat for him anymore. He doesn't have the stress. Thank God he's not under the spotlight. Or if he's like a go-getter and he's like, I think I'm the best, he's frustrated. Like, I could do a better job than Hank Brennan. That's how most lawyers are, I would say, is like they think they're the best at what they do. And it's like, I think I should be doing this. It's so frustrating. Why did he make this argument and not that? Why is he throwing me under the bus? It's one of those two. I don't know Lally personally. Thoughts on Bev letting Brennan argue outside of his written motion and misleading the court again. Commonwealth goes by unscathed again. She's so biased. So I think that he shouldn't be allowed to, but when we're pushing towards trial, some of the rules go out the window. They shouldn't, but are we going to delay? Are we going to say, okay, fine, put it in writing and file it, and then the defense is going to respond to it? Now, if the defense objects and says this wasn't in a written motion, needs to do it that way, the judge should force him to do it that way. If the defense either doesn't object or allows it to, that's kind of what happens. And if there is something that misleads the court, I don't know specifically what you're talking about. If it's about the federal investigation, we will get to some of that. But I don't like to say he misled the court if I don't know for sure that he misled the court, like when he said the feds completely misleading the court, then he corrected himself. So I'd have to get a little bit more specific on that. Defense doesn't agree that it was proven to be Chloe. Yeah, I wrote in my notes, how do we know it's Chloe? And if we know it's Chloe because like the Alberts or McCabe's or somebody said this is Chloe, did they know where she was the whole time? Is this the family she got rehomed to? Why did it take this long to get to her? All sorts of interesting discussions like that. Okay, so to finish off with Crosby, I really don't think he's qualified to testify. I really don't think he is. I think the Commonwealth would have made the same arguments after listening to them argue against Dr. Russell, and I just really don't think he's qualified. But once both sides do Daubert challenges and make these arguments, and a judge is letting one side's expert in on a particular topic, unless the other side's expert is so bad, judges, I would say more than 50% of the time, allow that second expert. and how Judge Cannone's been handling this case and being much easier on the prosecution than the defense, I kind of expect her to allow Dr. Crosby. I wouldn't, if I was a judge, I would strike him. I'd say, he's just not, you can go get somebody else. I'll extend it if I need to. Maybe, maybe not, because the trial is coming up and I don't want to delay the trial over this. They've had years to get somebody. But I really don't think he's qualified to. I think it's junk science, and I think it's going to be misleading and confusing to the jury. And we really just can't do that in criminal cases. But I could see the judge, again, in her discretion, saying, I allowed one side to have the experts, so I'm going to allow the other side, battle at the experts. Go ahead and battle it out. If your expert's so good, defense, she should be able to crush Dr. Crosby. That's just not good enough because of how jurors are, and they come into the situation not knowing any of the background. So we all in the background, lawyers, judges, know what's going on. We know which expert might be better than the others, but you can't put that in front of the jury. Same thing we talked about ballistic experts and other experts in other cases that just shouldn't come in. All right. Speaking of experts, next, the defense is trying to exclude the meteorologist because, I mean, again, he just crushes him. He's like, I've never heard a meteorologist say that the ground will be, in quotes, hard as a rock. He can go ahead and testify to the weather and things like that, but he's not a soil scientist expert. We'll listen to a little bit of Alessi's argument here. Some of it's kind of funny.
And he doesn't even begin to discuss that whole science. And Your Honor may recall in previous Daubert-Lanigan hearings, I cited to the Goodman case, the Pasteur case, and the courts in Massachusetts has said, in addition to going through making sure you've got a methodology, the court can also use it's the words of the court's common sense. So in addition to all the defects that I just covered, has anybody ever, all of us have heard a meteorologist in many different fora, most prominently on TV, talk. And what do they talk about? They talk about the weather, the forecast of the weather. What is the weather? We all know what it is. I've never heard a meteorologist say, today is going to be 22 degrees below freezing, there's going to be precipitation, and the ground is going to be hard as a rock. I've never heard it, because that's not what meteorologists do. So I believe in terms of common sense, in addition to the other arguments, I think common sense just tells one that this is not the kin of meteorologists. And interestingly, the Commonwealth doesn't cite and document one instance where Mr. Gilman has previously opined on the hardness of the ground. Not one. So in conclusion, Your Honor, he's not qualified in this area. He doesn't even state a methodology to come to the opinion, let alone show that if he had a methodology, it's reliable. He puts the opinion in quotes. I think the only reasonable conclusion from that is he's using layman, like an idiom, a term that people just use. You know, his head's as hard as a rock, whatever. But that's not science. And in order to give an opinion to the jury, the whole purpose of general acceptance, the whole purpose of Daubert, is it has to be based in science, and it has to be the methodology. There's none stated, and for that reason, and the others I've mentioned, Your Honor, Mr. Gilman, the meteorologist, should never reach a jury to talk about hardness of the ground.
Okay, and Brennan gets up and basically says, okay, Judge, we won't have him say that the ground is hard as a rock. But then, so it sounds like, okay, I'm conceding he's not going to testify to that. He'll testify to the weather, et cetera, et cetera. But he does want the meteorologist expert to discuss the ground freezing, which is basically the same thing. And I wrote down, unless he's not going to like that. But then Hank Brennan said, Judge, we can just have the EMTs and lay people talk about how hard the rock is. I mean, how hard the ground is. It's like, okay, if you can have lay people and EMTs testify that the ground was hard as a rock, that it was snowing outside, which is very obvious since, in fact, we have all the videos. It was cold because everybody understands how cold it was, and everybody can testify to what the temperature was that night because everybody looks at the temperature, right? Like we all do. Why do we need a meteorologist? This feels like overtrying the case. This feels like an unnecessary expert to me. Now, if they could say the ground is hard as a rock, you can crush a glass on the ground when it's this hard. If they got an expert to say that, I can understand how that might be important. I don't think it's a meteorologist. I think Alessi makes some great points, but I don't really know why we need a meteorologist. Especially when he has admitted that what an expert is supposed to do. And the real reason you're only supposed to be able to call an expert is if they can add to the jury, help the jury understand something that they can't understand on their own. That's really what it comes down to. One real quick second, Alessi hammers him on response. Alessi owned this argument about the meteorologist, but I thought this was funny.
In specific answer to your question, Your Honor, what do I respond to that? I think the Commonwealth very much recognizes the shortcomings that I mentioned, but its proposal to have a meteorologist talk about how ground freezes is still very much problematic, because just by way of example, how a ground, whether it's frozen or not, and how it freezes, I will give, Your Honor, citations to scientific studies that address and techniques as to how one has to do that. Benjamin J.G. 2005, freeze thaw effects on penetrometer resistance and shear strength.
Why don't you put those in writing? Was that just a Google search? I saw that you had it on your.
Actually, Your Honor,
Was that just a Google search, she asked? And I was like, man, is that what happens in her courtroom? Is people just come out and they read stuff that AI from Google just like spits out? He's like, no, Your Honor. In fact, it was not a Google search. And let's listen to what it actually was from.
the answer is no, it's not a Google search. I actually consulted with the former head of the National Academy of Science on geology, Dr. Donald Siegel, who told me and gave how it is that one determines whether or not ground is even frozen.
Okay, so that would be helpful to me.
So it's like, sounds like one of the foremost experts. And I don't think she was being offensive saying it was a Google search. I think she was just saying, like, I need to know how much credence I can put in what you're giving me. Sounds like a lot of credence. Did you notice how Hank put the video stuff on Lally? I feel like Hank has thrown Lally under the bus multiple times throughout the process. B&B said, curious, can the D appeal to a higher court to remove anti-Bev? She's so biased. It's just not going to happen at this point. They're not going to remove Bev at this point. Judge Cannone at this point. You guys are just always getting me. EMS, I'm in constant shock and horror of due process and constitutional rights violations in the U.S. justice system. Most of them could never happen in Brazil. Okay, we'll agree to disagree if anybody thinks that a different system is better than the United States system. I'm biased, right? This is what I work in. This is what I know. This is what I love. So I get it. Everybody has a different opinion. Does it matter if it was Chloe? All that matters is the looks like dog bites and doesn't look like a car damage. I mean, theoretically, even for the Commonwealth's expert, he says it wasn't Chloe or an animal bite or a dog bite. Like he says, kind of just cross it all off, but we're positive it's not Chloe because I did these molds and measuring. All right, next we get to the sanctions motion, which I think is the first part. We're going to listen to Hank Brennan make an argument. And I thought it was interesting, right? It has to do with the protective order and the fact that they inferred Trooper Proctor watched the whole trial. They have no basis of it. I kind of agreed. It was like, you don't really know whether or not he watched the trial. From my perspective, that's just something the judge can be like, I'm not going to say he watched the trial just because the defense said he did. But I didn't realize the text that was put out there was something that was protected by the protective order. We'll talk about what Yannetti says and how he apologizes for that and owns his mistake once again, which is what you're supposed to do if you're a lawyer. There's so much pressure on this case and so many outside eyes. Mistakes happen in so many cases from so many different lawyers, and we usually give each other grace. We're like, I get it. Thank you for correcting the record. Let's move on. But everything getting out there is what Hank Brennan is saying. We need to stop. And the sanctions that he proposes are sanctions I have never in my life heard before. So let's take a listen to his argument for sanctioning the defendant and what he wants those sanctions to be.
Didn't want to watch a closing. There was no good faith basis whatsoever that witness watched other parts of trial. It is an empty shell to make that suggestion, which then gives them the tunnel to put this information into the public. And when you look at the nature of the information, it's obvious why the defense wants this information to the public. It's part of the consistent public relations campaign they have sought. It is a month before trial, and rather than discuss the facts and litigate the facts in front of the jury, it is a deliberate, ongoing, strategic investment to reach the potential jury pool. And it doesn't matter if it's attacking the trial court, the state police, the prosecutor, the prosecutor's office, witnesses. It is.
So that's another little shot by Hank Brennan saying they'll attack the court, prosecutors, the witnesses, law enforcement, Because when you throw the court in there, you throw Judge Cannone in there and saying they'll even attack you on the defense side, Judge. How do you think she feels about that? Right? She's human. She probably reads some stuff, hears some stuff, watches some stuff. How do you think she feels about that? And she's the one making the decision on whether or not to sanction them in the way he's about to ask.
Is saturating the public with sometimes disinformation, parts of information that inevitably is going to make a juror's job much more harder. It is unfair to the court.
Listen, I try not to hammer people for grammatical mistakes and spelling errors. I know a lot of people were going off on Hank Brennan and have in the past and some of his motions, but it's tough. It's tough.
It's unfair to the people of the Commonwealth. It's unfair to the Commonwealth. It's unfair to the prospective jurors. And so not only is there really not a logical or a reasonable basis to put this information in, but when we look at the nature of the information, it becomes clear. And so we turned over this information 3 times. We did turn it over as a text message, a notice of discovery 51, a protective order was issued, docket 416. We produced it, notice of discovery 57. And again, it was a protective order. And then finally, notice of discovery 58 with a protective order. This is just some of the materials. It is beyond dispute that the defense violated that protective order. So in considering sanctions, I ask Your Honor to consider the history of efforts by the defense in this case to disseminate information or to make statements that should not reach a prospective juror before this jury trial starts in less than a month. Now, after they disseminated this information, it wasn't within 24 hours. It was within 24 hours. This was in the local news, the national news, newspapers, online, and it seems that was the very purpose it was spit out into the community. And so the Commonwealth's position is there needs to be a sanction to stop violations of protective orders and violations of the rules of trying to convince the public before trial about a certain side's position. We've had a history in this case that predated me, docket 111, docket 262, where there have been efforts by the Commonwealth to stop, prevent extrajudicial statements. And despite that, it has not happened. There's never been a sanction by the court imposing an obligation for the defense to stop. Rule 3.6 is clear. A lawyer who's participating or has participated in the investigation or litigation.
We've read this rule a ton with all the Diddy and Jay-Z and Baldoni and all those other cases.
Of a matter shall not make an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communications and will have a substantial likelihood of materiality prejudicing an adjudicative proceeding in that matter. It's important that all parties follow that rule. And there is no retort. The Commonwealth cannot fight fire with fire. I receive inquiries and calls, which I ignore and don't answer all the time because my obligation is a little bit different. It's to ensure a fair trial. Nevertheless, when these type of violations occur, there really is nothing to undo the taint. The history of these violations date back early on in the case, and they continue to this day. Fox 25, defense is quoted, certainly the Massachusetts State Police is involved. There are people that were in that house that are involved. Brian Albert is involved. Jeffrey McCabe is involved. The rest of the folks that were in that house, there's some level of involvement by every one of them. Specifically, 3.6 is particularly concerned about disparaging witnesses, about giving a one-side opinion that may not be based in fact and truth about a witness. It is specifically concerned about the credibility of witnesses. There's been an ongoing promotion to talk about ARCA and federal witnesses and what the opinions are, which aren't in line with reality, the reports, or the testimony. It is a campaign.
They're not in line with reality or the testimony. Like what? What is he talking about? Maybe he's talking about they didn't pay him. Can the defense now say ARCA was hired by the feds? Unfortunately, no, because that prejudice would still be there. But I don't know what Brennan's talking about when he says stuff like the ARCA federal witnesses and their testimony is just not based in reality. What? I feel like I'm kind of getting a vibe with him that, and again, when you contrast it with Alessi, who has an outline, he says where he's going to go, and then he looks at his notes and goes where he's going to go. Brennan sometimes starts getting on a roll, and then I feel like he just kind of starts talking and saying stuff and stringing sentences together, and it's like, what? Like, what has no base in reality? If you want to say that the federal investigation, which we're going to get to those discussions later, but to say the ARCA witnesses' testimony and opinions are not based in reality, I'm like, what? I don't get it. I don't get it.
In addition to this recent protective order violation that got attention that money couldn't buy for a party, other information that was provided in our case, then provided in a collateral case, was again sent out to the public domain. The defense has not only trampled over 3.6, they've alluded continually about matters that have no basis in fact. January 18, 2024, District Attorney Morrissey is well aware he's a target of a federal investigation. We're aware of today's hearing in Norfolk County Superior Court in the Karen Reed matter. In connection with this matter, at no time has the U.S. Attorney's Office named any person or entity. That was the response by the U.S. Attorney's Office after they implied.
Where was that made? Where was the January 18th comment that you just said? Where was that made?
That was made by Mr. Yannetti, and I have a clip of it. He also appeared on court TV with Ms. Reed. The Commonwealth is moving for a protective order for these letters after revealing part of what they contain. The Commonwealth wants to keep the remainder of the letters hidden because the letters contain information that will embarrass District Attorney Morrissey and his office. The letters demonstrate that he's a target of a federal investigation for what his office has done to Karen Reed. This is,
Where was that court TV again?
I can get the date for your honor. Recently, on February 18th, when we were arguing discovery motions, Attorney Little stood up, invoked the boogeyman, a federal investigation, attached themselves to.
All right. So we're starting to talk a little bit about the federal investigation. So my dad, I saw just pop in the background. So I'll bring him in to get his opinions here as well. But what's important is Yannetti also says that we have to make sure that we're not being held to what we're talking about in court, the same as what we say out of court when it comes to the rules of ethics and if there's going to be sanctions by the court, things like that. So that's important, but Brennan sticks to the fact that this was on court TV and et cetera, et cetera. So, all right, let me bring my dad in here now. Everybody say what's up. Hello, can you hear me?
Hello. Yeah, I can hear you fine. Can you hear me?
I can hear you. So
Good.
There's a couple things going on here. I was going to bring you for the last, there's kind of a next section we're going to talk about, but Brennan, the prosecutor's asking for sanctions to the defense for violating the protective order. Part of it is from the feds. Part of it is about 3.6, what lawyers can and can't do when, speaking to the media when they have a case on trial. And one of it is attached to a text message that the defense publicly or put in a public document that they filed that basically said, Attorney Jackson's an a-hole. I couldn't watch the closing. We'll talk about what the defense's response is. But Brennan also mentioned how the defense has been saying in the media that Morrissey, the district attorney there, is a target of a federal investigation. The feds came out and specifically responded and said, we have not named a specific target. We have not named anybody personally as being a suspect or anything like that. So basically they're saying things that are not, maybe not wrong, but not confirmed. They're taking leaps and making reasonable inferences based on what they know. And he's saying that's a big problem. They're creating this boogeyman out there with the federal investigation that is just not true, is what he's discussing here.
Okay.
Birchmore case, and then proceeded to list off a number of troopers' names with no real association or relevance to any discovery motion. And this was a tactic to besmirch these hardworking, dedicated public servants simply by attaching them to a federal investigation for which there is no boundaries. Well, within 24 hours of those arguments, the Norfolk County District Attorney's Office was contacted by the United States Attorney's Office. And let me make crystal clear, they made clear that I could inform the court, there is no longer any federal investigation into the investigation of John O'Keefe's death or any related matters. It is closed. It is over. So all those implications.
He couldn't be clearer that it is closed. It is over. And we've talked about this in the past about how the feds handle investigations, especially something as sensitive as this. They don't always tell you, nor do they have to tell you, if you're a target, what they're investigating, who they're investigating, if it's open or when it's closed. Why do you think they decided to tell the Commonwealth And we're going to find out a little bit later. Maybe I'll hold that part. Let me just ask you this part. Why do you think they told the Commonwealth that the investigation is closed?
Well, because a couple things. One is it's been inferred that the investigation is about a public figure, which I guess is the district attorney. And so here we have a public figure, which I think is elected. So we have an elected official that's being clouded by the investigation. Secondly, it's having an impact on a court hearing, a state court hearing, and a judge having to make a ruling based on this. So I think that they found exceptional circumstances, and it does happen. When you find exceptional circumstances in order to reveal this, I mean, let's remember they did it years ago when Mrs. Clinton was running for office. They said, there was no investigation. They do these things in order to make sure that what they're doing does not impact the voters, or does not impact, in this case, it could impact a criminal case. So they do it. They have to, policy would have them get permission from Washington before they made the disclosure. Plus, interestingly here, they did not actually make the disclosure. They told this prosecutor that it was closed, and they told him, you have permission to say it. They themselves never actually have come out and said it.
Yeah, and
I think that's an interesting twist.
And that's what I was going to talk about later, but we can just talk about it now. They filed a letter. Gosh, I really want to hear it come out in court first. Let me just hold it. Let's listen to it a little bit more, and then we'll continue the conversation.
And innuendos that erode at the objectivity of our potential jury pool. Well, they become more egregious when you see that they're not based on reality of fact. And so I submit that the ongoing, deliberate, purposeful poisoning of the potential jury pool is not only wrong and unfair, it needs to be stopped. And this last incident of taking a private email under a protective order and putting it in a pleading for the world to see is just yet another example. It's one small step in the marathon. Now, they've made their campaign clear why they're doing it and how they're going to do that. If there's any doubt whatsoever about the intentions of these tactics, I've submitted audio clips to you under seal, and I won't repeat what's in them. But that makes abundantly crystal clear why this is happening. And so, inevitably, the court has the ability to sanction. And as an aside, although an accused stands in a different or sits in a different position than the attorneys, grand jury minutes cannot be disseminated either. Not just the paper, in substance, they can't be. Doesn't matter who you are. And so the Commonwealth asks the court to consider sanctions so that we can have a fair trial, so that it doesn't limit the parties. It's not retaliatory. We will abide by the same rules. What I suggest is that from now until trial, all pleadings submitted by the defense should be under seal so the court and the Commonwealth can review them and make any objections if there's any material that's private, so that there's no oversights or mistakes or dissemination of protected material. And then
Have you ever heard of a sanction like that, where just the defense is under seal and the Commonwealth gets to review it before it becomes public?
No. And I've never had a situation where every pleading has to be filed under seal.
You said,
I've
hold on,
never
you
had
said
that.
you never had that, or you have?
Never.
Well, I was going to say, if I was a prosecutor and I wanted this because I really was scared that the defense was going to continue to do this, I would say, Judge, let's just file everything under seal. Once you look at it, then it can become public. So you seem like you're being even-handed, at least. You're seeming like you're not trying to hide anything. And if they have to file it under seal, then you can file it under seal too. Why would just one side automatically be public and not the other side? Just seems completely unfair, makes no sense to me. Good luck explaining that to a higher court, that everything from one side being the criminal defendant with the rights to a fair trial and a right to a public trial, all of that having to be, she would have to find violations of the protective order and basically intentional violations by the defense and probably multiple violations in order to do something like this. Don't you think?
Oh, absolutely. And I tell you, I'm not, do you think that he would be opposed if somebody said, let's file everything under seal? I mean, he'd look like an idiot if he said, oh, no, just the defense. So I
that's what he just said. He just said,
I know that's what I'm saying, but I'm saying he would just, it just is totally unfair. I've really never heard of every pleading of either side being filed under seal, every pleading, because the judge has sanctions the judge can use against lawyers who violate the orders.
Right.
And therefore, I just don't think filing everything under seal is really the way to go.
Talk about a bunch of unnecessary work. Like, it was happening in Koberger where they weren't filing everything under seal, but basically if either side ever wanted something to be under seal, and if it was even questionable, it was under seal. So it felt like almost everything at some point was being under seal. But again, I'm not saying it should happen that way. I'm never for that. But if you're going to make the ask because you're worried, both sides, just say both sides. So it at least seems like we're trying to be even handed. I think
that's absolutely right.
I think that's the end of this clip. Let me just make sure.
Okay.
The court and the Commonwealth does not have any objections, then those materials can be provided.
If the Commonwealth does not have any objections, then those materials can become public.
Publicly on the docket. Also, the Commonwealth.
Yeah, that was the end of what I want to say. But so should they clear their legal arguments with Hank Brennan as well? Is that something that he wants? Oh, actually, I wanted 30 more seconds. Let's see what it says.
Suggests that the court impose a sanction that the defense must follow Rule 3.6 as the Commonwealth does. No more symposiums on the courthouse stairs. No more interviews with national media. No more statements to press privately behind the scenes over a coffee, putting out information, oftentimes inaccurate, to sell the story before the trial starts so that we can have a trial on fact.
So basically, he wants a gag order.
Right. And I don't know why he doesn't say it.
Can the defense make a motion to sanction Hank if they find that he has done something worthy of them filing a motion for sanction? Yes, they're not just going to file one just to file it. But yeah, of course, anytime you think a lawyer does something worthy of sanctioning, you can file that motion. Peter, why is there still discovery if the investigation is over? In a trial, the jury usually evaluates the credibility of witnesses, right? Yes, that's right. But who weighs the credibility of the judges and the attorneys? Well, nobody except maybe appellate courts weigh the credibility of the judges. The judge weighs the credibility of the attorneys, and then the jury, at the end of the day, determines whether or not they can believe a jury, or believe an attorney. But expert witnesses are a little bit different. Weighing the credibility, yes, the jury ends up doing that, but there is a bar, and the judge is the gatekeeper, that if they cannot clear that bar, they can't even get in front of a jury because a jury is so likely to listen to what an expert has to say. Lita, Peter, USA placed 26th position for best judicial system. That's far from the best. Well, I don't know what rankings you're using. We can agree to disagree. I've never, ever, ever heard of another country that does it as good as we do. That's just my opinion. Duncan, how could Judge Cannone allow this expert to testify as to the cause of the injuries when she's already ruled that one absolutely has to be a medical doctor to do that? So just because she said it has to be a medical doctor is not actually the legal standard. So theoretically, legally, she could go back on her own position because it is not the legal standard. It's kind of like when law enforcement creates a card that you have to read for Miranda. That does not replace what the rule of law is for Miranda. That still exists. So if the card is wrong, the case law is what rules. Have you seen the Morrissey video from 2023? He straight out said Karen Reed is guilty. I'd like to hear your opinion. I have not seen that. That would be absolutely inappropriate for a prosecutor to do in a criminal case, but it happens. So it's not like I'd be shocked. Raven, why can he twist truths, correct it, and not get called out? And the feds didn't charge Karen with anything from the investigation. I infer she didn't do it. I don't really know how to answer that, but I think it's probably more of a comment than anything else. Dana, if it's closed, does that mean no one is being investigated? So this is a good point. Just because the feds say it's closed and the investigation's over and nobody's being charged, doesn't mean it's going to stay closed. Doesn't mean they can't reopen the investigation, right? How often have we seen investigations closed and reopened when, you were working for the feds or as a criminal defense attorney, where we represent somebody that's a target of investigation? It goes away. Great. We did a great job. Doesn't mean it won't come back, right?
The only limitations is statute of limitations.
Exactly.
And they're right. So anytime they get new evidence or a new witness comes forward, as long as the statute of limitations hasn't run on the crime, they can reopen the investigation.
Reese's mom said, don't you find Brennan's argument that the Commonwealth is entitled to a fair trial somewhat disingenuous, considering the overwhelming advantage that the state Commonwealth has? So the state and the Commonwealth has the advantage every trial, and yet every time they're making arguments, they say we're entitled to a fair trial to judge. So it's very common, and it just kind of is what it is.
Keep in mind, and I realize that everybody thinks people are guilty. I mean, yeah, we understand that, but keep in mind, there's the presumption of innocence, and the burden of proof is always on the prosecutor. So, and the only place where there's a quote level playing field where both sides get to speak up and the rules are followed are in the courtroom. Otherwise, that's what he's complaining about. Outside the courtroom, things are going on, and we can't control it. But in the courtroom, things are more controlled, and the judge controls it.
Yannetti responded to this argument. He's the defense lawyer. Basically, he apologized. He didn't realize the text message was part of the protective order. He didn't connect it. He also makes a good point that while maybe it was a technical violation of the protective order, everybody already knew Proctor hated all the lawyers. Now he just specifically added Jackson to the list. So really, how prejudicial was it? And he didn't violate the main purposes of the protective order, but he was very apologetic. He thinks no sanction is necessary, obviously. They go to the sidebar. They make a bunch of arguments at the sidebar. Then they come back, and Yannetti wants to make a correction on the record because Brennan accused Eliza Little, which is one of the female attorneys on the defense side, of some wrongdoing. And after some private bench conference arguments, Yannetti's like, I want this to be public. I want to correct this on the record. Judge obviously allowed it. So let's take a listen to that. And this is where we get more into the protective order. Sorry, the federal investigation.
Right ahead.
Thank you, Ron. And thanks to the court for allowing me to make much of my argument at sidebar. The only remaining argument that I can make in.
We did that because that was material that needed to be done at
Oh, I understand, Judge. No, and I'm
Just
thanking,
want the record to be clear.
I understand, and I'm thanking the court for that. The only other argument that I'd like to make, and this is appropriate to make in public, because there were allegations that I believe, misconduct regarding the existence or non-existence of the federal investigation, specifically directed at Ms. Little. The timeline is important here as well. Mr. Brennan himself was provided and sent a letter on January 30th of 2025. The letter was directed to him specifically. We obviously received a copy of it. And in that letter on January 30th of 2025, the first assistant U.S. attorney, Mary Moraine, informed Mr. Brennan that the federal investigation was ongoing.
That's January 30th of 2025, a letter sent to everybody. And Karen Reed said on the courthouse steps, I can't remember, she said 4 or 6 page letter, single space. So a lengthy letter from the U.S. Attorney's Office that the federal investigation into the investigation of John O'Keefe's death is ongoing. They send it to Brennan. They copy the defense. So the defense gets a copy. Okay. So we're all tracking. That happens on January 30th. That's why the defense is coming out saying, oh, it's still ongoing. Of course, they still use it to push what they believe is happening and what they believe the narrative to be in this case.
Her words. Mr. Brennan knew that. It was after that letter, I think within about 3 weeks, we were in this courtroom, and Ms. Little had mentioned the ongoing nature of the federal investigation. Not only was that truthful, that came from the horse's mouth. It came directly from the U.S. Attorney's Office, and Mr. Brennan was aware of that because he personally got the letter. It was only after that that Mr. Brennan has reported to the court that the federal investigation later was closed.
Can you give me dates again, please? So what was the date that Ms. Little made that statement, and what was the date that you all found out?
So basically, when they're trying to figure out when did the defense attorney say the federal investigation's ongoing as part of their argument to get some discovery, and did she know at the time that in fact the federal investigation was over? First off, what does it mean to know something, right? Because we're gonna hear about how we know this information that the federal investigation is over, and I tend to believe it, by the way, but that doesn't mean everybody has to believe it. Just because I believe it doesn't mean, especially the defense in this case, dealing with what they've dealt with, doesn't mean they have to believe it.
If I was the defense, I wouldn't believe it till I saw it in writing because of the problems they've had with the prosecutor's office. So, I mean, neither one of these sides believe each other. So, why is it that you believe it? I mean, the U.S. Attorney's Office had the foresight to send it in writing on January 30th. So when they closed the investigation, why didn't we get a letter in writing that they'd closed the investigation?
That's exactly the point. Right. I feel the same exact way. Now, the prosecutor, who's a barred lawyer in this state, is about to say it. He already did say it. He's going to say it again in open court on the record. So I would be shocked if he's just flat out lying about that. I know a lot of people in the chat would not be. So I don't think he's lying about that. I do think somebody in the U.S. Attorney's Office did tell him it was closed. But I would agree with you. I think the defense is entitled to say, we don't believe you. Or they're entitled to say, we would like to wait until we get it in writing. And so if they're going to continue on saying, we think the federal investigation is still ongoing, I don't think the judge can tell them that they're wrong. Just because the prosecutor told you it's not, I don't feel like you have to believe that. I really don't. Especially when you already have the MO of the prosecutor's office to send you something in writing, like you said.
And you also have them giving you, in this case, some funny evidence in this case. So, you've got some reasons to doubt the prosecutor.
Each other. They both think each other's lying about everything. So
Right.
get it in writing, get it from the source. Just because one side says it doesn't make it true, right? I mean, that's how life
Absolutely.
is sometimes.
What Mr. Brennan just announced.
Okay, so January 30th was the letter. We believe February 18th, when we were before this court, was when Ms. Little made that statement. And then it was thereafter. I can't speak to when Mr. Brennan says that the federal authorities contacted him, but it was after February 18th.
When did you hear the information? When did you hear the information that Mr. Brennan just told us?
Mr. Brennan called me to inform me of that. I don't remember the date. Maybe perhaps he can tell the court when that was.
Was it prior to February 18th?
No, it was after February.
It doesn't seem like they're saying Brennan lied. It seems like maybe they do believe Brennan, that he called them and told them, and that's fine. But again, there's nothing wrong with waiting for some confirmation in writing.
18th. Yeah, no, it was definitely after February 18th. Ms. Little reported the freshest information that we had truthfully to the court. Just in closing, Judge, this was not a boogeyman. The federal investigation existed. It was confirmed to have existed multiple times as late as January 30th, and it's right there in black and white.
I think it was only the boogeyman because it did scare the Commonwealth, right? That's why I think the boogeyman is an apt illustration, except for the fact that it was real. It may not be anymore. Maybe it is over. Brennan is very adamant that it is over, but that's a real concern. And that's something that made this entire case so unusual from the jump, the fact that the federal investigation existed. Brennan's going to come up and respond and give us some dates about who exactly told him what and when he told the defense.
Any follow-up, Mr. Brennan?
Ms. Little made her argument on February 18th. The Norfolk County District Attorney's Office was contacted about 24 hours later on February 19th. I gave written notice and called Attorney Yannetti on February 26th.
Why do you think he waited a week?
I don't know. That's a funny thing. That's funny.
That right there, I was like, wait a second. You wait. And by the way, a bunch of reporters, like local reporters, reported that the investigation was over after February 19th, but before February 25th or 6th or whatever he just said when he told the defense. So somehow other people were finding out about it and it didn't leak from the defense because the defense didn't know who he's accusing of, disseminating all this stuff publicly. That's very strange to me that he wouldn't immediately inform the defense in writing if of a good fact for the Commonwealth like that.
Part of the argument is
Somebody said he waited for it in writing. Did he get the writing? Because it doesn't seem like there's been any
No,
writing, right?
I
Unless
don't think
we
so.
don't know.
He would bring it up if he got it in writing.
I would think so. Maybe if we're trying to give him the benefit of the doubt, maybe he waited, asked the U.S. Attorney's Office, can I share this with the defense? And until they said yes, he didn't share it. I don't know, but the U.S. Attorney's Office would have to know that that's discoverable information. If they're going to tell the Commonwealth, they have to know the defense is going to find out.
not that the defense was aware it was closed and continued to persist. It is insinuating and suggesting for years of this amorphous impropriety. It is trying to bootstrap their arguments, claiming, yes, that there's a boogeyman, that something is happening in the federal court, but they can't talk about it when the reality is now that that case is closed.
I may just briefly respond, Judge. I'd like the court to take a particular care when we're talking about extrajudicial statements, not to take into account statements that were made in advocacy in court to Your Honor. The Commonwealth referenced a statement that I had made regarding the federal investigation. That was in a courtroom setting. It was not an extrajudicial statement.
Also, under the umbrella of the rules of professional responsibility.
Correct.
guarantee it was not within.
All right, there is another little clip I want to play at the end, but I just want to make sure if there's anything else we want to talk about with the federal investigation. So there's
Well,
some
one of the things that
Go
they
ahead.
complained about that I do want to say, he complained about the fact they revealed a statement that Proctor said, I believe that Jackson was an a-hole or something like that. I think that was the statement. Think about that. What impact could that have on guilt or innocence? Or what impact could that have on a jury? None. So even though he probably shouldn't have revealed it, it's not the kind of thing that's going to have any impact on jury selection. So I don't think the judge is going to take that as being a really serious violation.
Yeah, I mean, I don't know the answer to that of what the judge is going to do necessarily. I have my guesses, but I could understand how you don't want to make a witness, especially the lead investigator, look bad or look like a jerk. And if you reveal that text message that was subject to a protective order, it makes him look like a jerk. Problem is, that's about the least horrible text message I've ever seen from Michael Proctor. So It's like, it didn't really have that effect. And that's what Yannetti said. It's like, if we look at the purpose of the protective order, this really didn't do much. PTS said, is it strange that the feds would only notify one party when they have previously notified both? So I'll let you answer that, but I want to make sure we understand. Yannetti used language like the letter was sent to the Commonwealth and a copy was given to the defense, not necessarily that the defense was also notified. So I'm not sure about that language.
That's the way I understand it. I understand that the Commonwealth got the letter.
Okay. Chief Rafferty's press release says the investigation is complete and will be closed. It's in Canton's twit. I don't even know what that means. But so again, we've seen some different verbiage used, like it will be closed, it is closed, it's over, no charges, investigation is done. Do you read anything into these semantics? Or I really think this just adds to our argument for what we both said earlier, that this is why we need it in writing and explained exactly what's going on.
Right. Because these people are people that have vested interests. Chief Rafferty's got a vested interest in making sure that the public knows it's closed. The prosecutor has a vested interest in closing the investigation. So we're only hearing it from biased witnesses who have a vested an investment in this being closed.
Hank specifically said the investigation of John O'Keefe's death was closed, not the broad investigation. He chooses wordplay to manipulate the public, does it a lot. Here's the point. Anybody can say anything they want about the federal investigation. The truth is nobody knows except for the feds. And we only know what they're going to tell us, because they don't have to tell us if they're investigating somebody specifically. They don't have to tell us if this is part of something bigger, right? They're investigating this office with 20 cases, or if it's just one case, if it's just one cop, if it's just the DA, if it's just one ADA, they don't have to tell you. So that's the problem. And that's why there's a protective order, is you don't want either side to use this when they may just be blowing smoke, which is why the ARCA witnesses, you can't really say how they fit into the federal investigation because we may not know. But what we do know is what their opinion is as far as it relates to the car and John O'Keefe's injuries. And that's why they're allowed to testify about that in the trial.
And the prosecutor used the words anything related to the death of, those are the words he used. And I'm not sure we can really rely on that to be, are those the same words the U.S. Attorney's Office used?
Or is that how the defense would explain it if they got the same information?
Right.
Peter, how have you not seen the Morrissey video? I didn't watch anything before the first trial. So since the first trial, I've basically watched everything since. Forrest, dump hostage video, please, Morrissey 2023. If you guys want me to take a look at it, send it to my Twitter DMs at lawyer on there. Miss Little was referring to the Birchmore case. Brennan said the O'Keefe case was closed by the feds. Can that be two separate federal investigations? Sure, it could. And again, it all depends on what the feds are doing, how they would define it. Do they see those two cases as connected or do they not? These are just answers we don't know. This right here. Why didn't Bev chastise Hank right here for accusing Little when he knew he gave her the info after the hearing? So that is a good point. He complains about what Eliza Little said, yet when she said it, that was the information she had. Within 24 hours, he found out that information was incorrect, but when she said it, it was correct. Rebecca said, why can't they have a closed session and talk to the feds? Why don't you talk about who controls this type of situation, why it doesn't happen like that, where it's just simple. Let's all sit in a room and talk about the truth and talk about the facts.
What the feds would say was, hey, sure, you can have all the meetings you want, we won't be there. You can, thanks for the invitation, but we won't be there. Who can question me? I'm a Fed. The state court judge, forget it. State court judges are meaningless to me. The state prosecutor, forget it. He's meaningless to me. A local law enforcement agent, forget it. Meaningless. So, the feds don't have to talk to anybody. They don't have to answer anybody's questions, and they know it.
And they don't want to, right? Because if they
Right.
they know beyond a shadow of a doubt, if they said, we were investigating Morrissey, the defense would just run with that. If they said, we weren't investigating Morrissey, the prosecutors would run with that. If they gave any little bit of information, one side would run with it, and they don't want them to. And just because a federal investigation ends doesn't mean there was no evidence of wrongdoing. It just means they didn't have enough that they felt like they could prosecute beyond a reasonable doubt and go win, because that's what federal prosecutors do. They go win 99.9% of the time. They don't. I guarantee you they would not have taken the Karen Reed case. It is so far away from 99.9% chance of winning, but the feds have such a high standard that just because an investigation went away doesn't mean there's no wrongdoing. Yet again, we know the Commonwealth will say that's what it's evidence of. There was no wrongdoing. The investigation ended. Okay, if that's what you want to say.
Well, plus the investigation ended does not mean that the information they gather will ever be public.
Oh, correct.
That's right. So investigation's over. Well, what did you find? Hey, tough luck. What did the grand jury find? What's in the FBI 302s? No, sorry, you can't have them. So they might have gotten tons and tons of evidence, but no one will ever know.
Yeah, no, I agree. Caitlin Healy said, how can they find a jury that hasn't heard about the case considering its publicity? What questions do you think will be asked to the jurors regarding case knowledge? I mean, from my perspective, it is the all-important situation of voir dire, jury selection, questioning these witnesses and talking to them about their knowledge of the case. Do you agree? You have anything to add to that?
No. Jury selection is going to make all the difference. Plus, I think they're going to end up having some people that have heard something about the case, but they're going to try to find people that, although they've heard something, they still have an open mind, or they still have the ability to make a judgment. You'd be surprised, and your listener will be surprised, how many people they're going to question that have heard nothing about the case. It amazes me every time I've had a high publicity case at what a large percentage of people don't read the newspaper, don't watch the television, don't listen to social media, and so they know nothing about the case. It happens all the time.
Please check your X. I sent you the lettered that came out today. It says investigation is completed. It will be closed soon. Words matter. Investigation is completed. It will be closed soon. Words matter. Yes, and we talked about that. That's from Rafferty. So we talked about that statement already. Allison Cosgrove, Peter, can the defense request a change of venue and thereby change the judge for the second trial? Seems like that would solve a lot. It's a little too late for that now, but I don't think the defense wants to change the venue. Maybe change the judge, but I don't think they want to change the venue.
And even if they change venues, a lot of times the judges go with it.
Yeah. In Koberger, it changed because that judge, I think, is retiring. Ryan F., how likely is it, or if the judge wants to get off, then they can. It's like a judicial discretion thing. I don't think Cannone's wanting off of this. How likely is it the feds close the investigation as part of a strategy? Example, close it so people think they're in the clear. How often are investigations reopened? What would you say?
Well, they're not reopened very often.
Right.
Because normally when they're reopened, it's going to be some extraordinary event. I don't think they'd close an investigation as a strategy. I'm going to ask you, that just really doesn't make sense to me to do that. So I don't think they do that. Plus, I'm going to be honest, I don't think they really give a hoot about helping the prosecutors in this case. I think they did it because they thought it was the right thing to do to make that disclosure if they close the investigations. But I don't really think they care about helping the prosecutor. I mean, look, they gave the defense those expert witnesses. So I don't really think they care one way or the other. I think the prosecutors have to sink or swim on their own.
Rebecca said, I'm saying they could be asked if the investigation's over. I get it, Rebecca, and it makes logical sense. It's just not something that they'll do. They'll communicate in the ways they want to communicate when they want to communicate. Johnny, in my opinion, this case is riddled with appellate issues. If, in fact, Karen Reed's found guilty on any of the 3 charges, what would your biggest issue on appeal be? Thanks for all you do, Peter and George. I think this is a really long answer. If you want to give, your first thought, what I'm going to do is I'll save it for after the trial. That's usually the best point to talk about the appellate issues. We see how everything comes out in trial and get our answer.
Well, the second trial is a whole new ball game. So the appellate issues will come out of the second trial, with the exception of the issue of the judge, whether she should have dismissed certain counts if they couldn't find guilt on certain counts. That's the only issue that might remain. Otherwise, all the other issues start anew in the new trial.
They should reach out Cash because he's all about transparency, allegedly. I don't think that would happen, in my opinion. Christina Rex asked the feds today, still won't comment. Exactly. That's what I'm saying. They comment how and when they want to, and nobody's going to force them to do it differently. And I don't care how many people are asking or how interested the media is in this. If they don't want to comment on it any further, then they won't. Even if Cannone wanted to, like, you don't hear Judge Cannone doesn't try to even push the feds. So when they say the feds say you can't have it, she's like, okay, because she gets it. And that's just kind of how it is. All right, we've gone overtime already. Let me just kind of summarize the end. They agreed to continue it, the motion to dismiss, a little bit when they were talking about the scheduling order change, but Jackson said he's going to be ready tomorrow. So they're going to argue the motion to dismiss tomorrow, as well as some other motions. So we're back in court. We'll be doing another video tomorrow discussing what happens in court. So you're not going to want to miss it. Make sure you're subscribed and the reminder bell is clicked. I will check out the Morrissey video. I'm sure some of you guys sent it to me. Maybe I'll do a quick video on that and post it at some point this week. I appreciate you guys joining me. Dad, thanks for jumping in here at the end of the video.
Anytime.
Everybody, make sure you hit that like button. Till next time, we are out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.